touch briefly on the Klansman trial that continues. A lot of this week's happenings in the courts has to deal with recordings that have been transcribed. So one of the defendants, while he was working with the police, he said that he downloaded an app on his phone. So I'll read on, and so that you can hear what's happening. So on Monday, the Crown's case hit a snag after it was disclosed that other than a scene of crime photograph and evidence of the Crown's witness, there was nothing else available from the police in respect of evidence relating to a murder, which is count 15 on the 25 count indictment. And then 2 of 3 transcripts of the secret recordings of alleged members of the One Don Gang were blocked on Tuesday from being entered into evidence after defense lawyers raised objections. And keep that in mind, that the defense lawyer raised objection, because I'm going to touch on it a little bit later. And then yesterday, the prosecution informed the court that they will be calling 4 police witnesses to establish the chain of custody for the recordings. Because according to the prosecutor, they had not anticipated that the defense would object to items being presented in evidence. They never watched Perry Mason years and years and years ago. The defense always objects to things. You always should have a rebuttal to the defense's objection. Apparently they did not. So that's why they went no. So that's why today, starting today, one of the policemen was on the stand to try to rebut the defense's objection with regards to the chain of evidence for the recordings and how it got transcribed and all of that stuff. So I'll read on. So Brian and co-accused Jazeel Blake, Michael Whiteley, and Brian Morris are each charged with facilitating the commission of an applicable offense by a criminal organization in respect of the murder of an unnamed Rastaman. So on Monday, what happened is those defendants have been charged with murder in the death of the Rastaman. The Crown has no other evidence to put them at the scene of the crime other than a photograph that they claim shows them there. Again, the defense objected to that particular item being entered into evidence as an exhibit. So they were prevented from doing so, based on the basis that the witness's assertion that he had seen the incident and had identified the dead man for investigators from a photograph lineup was insufficient. Herein lies the problem, that there is not sufficient evidence at this point to demonstrate that the witness is able to properly identify him from the photographs. So I can't go with you on that, Chief Justice Sykes ruled. All right. And then it says, for the second day in a row, prosecutors' attempts were again railroaded in their attempt to have several pieces of evidence authenticated and entered as exhibits into the court's records. This after defense attorneys objected to the admission of 2 transcripts of the recordings of alleged conversations between accused members of the gang who are being tried before Judge Sykes again. So they objected against the evidence being brought forward against the background that the Crown had failed to properly establish the chain of custody for the documents, right? So witness number 1, who is a former gang member turned state informant, testified that he gave the police 3 phones with recordings of conversations between himself and the members of the gang, including the leader, Black Man. The witness also testified that he had downloaded a call recording app that was set to automatically record multiple cell phone conversations, which were also saved. He said that he forwarded the recordings to the cops, and when the memory became full. And then he said he also took it back to the counterterrorism, to the CHIT branch, where the recordings were transcribed. As the recordings played, the witness said he identified each voice heard to the cops. So while the recording was played, whenever a voice come up, I said something, him tell the cops say such man and such man. The witness, who said he started working with police undercover in 2018 while Brian was incarcerated to help dismantle the gang, had told the court that 2 of the phones were given to him by cops and the 3rd was given to him by a member of the gang on Brian's orders. So the transcribed version of the recordings, the judge state, based on the defense's objection, that those transcriptions cannot be entered into evidence, even though the prosecutors are stating that they did bring forward the person who transcribed the transcripts. So she testified that she was the one that she listened to the tape and typed what she heard, presented the document to the cops. And she identified the contents of the transcript as it being her material that she typed and hand based on the recordings on the CD, and she handed it over to CHIT. Again, the transcription, she transcribed over 170 pages of recordings. How is it that the prosecutor did not think that the defense would have an issue with this and have an objection so that they could rebut the objection? How? And why was this not entered into evidence prior so that it could be a part of the evidentiary package given to the defense, so that now they don't have to be scrambling to put the policemen on the stand now to show chain of evidence? I don't understand. I don't understand that. I do not. So Lyde McFarlane, who is the attorney for Brian, raised the first objection, saying, "I thought my learned friend was only going to ask that it be marked for evidence. This is a document that they were attempting to put in the hands of the witness, that he worked with the police to gather evidence by secretly recording the..." boy. So right now, they've called the 4 police officers. One of them is on the stand. So I'll let you guys know next week what happened with that. If anything, if there's any more objections. But this week, the prosecutors got 2 big hits against them in the trial. And based on how the case is going, it was going good so far when the witnesses were outlining what they did and all of that stuff. But big hurdle here for them to overcome is identifying that what they heard on the phone app is what's on the CD, is what was put on the CD, is what the transcription person heard, and that's what she transcribed. So they have to, they're gonna have to prove that nothing, no fuddy-duddy, no funniness never go on with the CD. Them never add anything to it or take out anything to it, and all of them something there. I'll keep you guys posted. Because this is just This part right here is amateur night at in the Jamaica courts. Amateur night of the based on the what the prosecutor is doing. Enid says same thing I'm saying too. Right. Amateur night. Amateur night. Right this up. But I'll keep you guys posted.